Good morning, Wednesday, March 12th. It's 9 a.m. We're going to spend some time going over S45, which is the right to farm bill. We've asked Judiciary to come in, Senate Judiciary to come in. They've sent in Senator Norris, and welcome, Senator Norris. The floor is yours, sir. Step right up.
Thank you. Good morning. For the record, Senator Bob Norris, Franklin County, and the town of Elberg, and the county of Grandon. There you go. I got to come in here to give you a quick walkthrough of the bill here. Actually, I was assigned this project. Full transparency. So S45, this is not the completion of the bill. We're supposed to get the final draft today. If any amendments, any changes, whatever else, we don't anticipate any. If they do, it's very minimal at this point in time. But let's council will be in today so we can vote on this bill. So we're coming towards you. The bill's 7 pages long. We're not going to cover all 7 pages, I can assure you. I'll start with S45, the right to farm. And basically, this is about the only point I'm going to read is the statement of purpose of the bill as introduced. This bill proposes to amend the protection against nuisance suits for agricultural activities under the Vermont right to farm law by providing that an agricultural activity shall not be a nuisance or trespass when the activity complies with generally accepted agricultural practices. The nuisance and trespass protection for an agricultural activity would not apply whenever a nuisance or trespass violation results from negligent operation of an agricultural activity or from a violation of state agricultural water quality requirements. This bill would also provide that an agricultural activity shall not lose nuisance or trespass protection due to a change of ownership or cessation of operation of not more than 5 years. A change of crops produced or a change of farming methods or conversion of a farming practice or agricultural activity to another farming method, practice, or agricultural activity on a farm. Yes, this act will also provide that a person shall not bring court action based on a claim of nuisance or trespass arising from an agricultural activity unless the person and the operator of the agricultural activity at least once attempts to resolve this through mediation, the issue or dispute that the person has concerning operation of the agricultural activity. That basically sums up everything. So if we start to go through the bill, you may hear some repetitive type things. If you have any questions, by all means, please ask. The next.
What was it before that, Senator? What is this changing that the farmers didn't have protections from before?
Basically, and we're going to get into that. The biggest change in this bill is, as it stands now under Vermont law, is someone files a complaint against the farmer. Okay. And it's up to the farmer or farmers to prove that they're not in violation of what they're being accused of. So they're going to spend thousands of dollars. We took testimony from a farm. They spent thousands of dollars to refute the claim that they're in violation of anything. They've even gone as far as to now plugging up their tile drains. Tilage, you know what draining is? So they go around and they're actually plugging each one of these until this can be fixed or remediated. And they're losing thousands of dollars in the process. They spent thousands of dollars doing this. This does not protect farmers from suits being filed against them. However, it shifts the burden of proof, as I'm sure some people here will realize that the state has the burden of proof when it comes to beyond a reasonable doubt when they charge them. This changes the burden onto the individuals who are filing the suit versus the farmer proving their innocence, so to speak. And it's based upon preponderance of the evidence, which is the 51%. Common sense tells us that, yeah, it appears that it may be, because there's 3 levels that we use: preponderance of evidence, clear and convincing, and the highest level is beyond reasonable doubt. So this offers some more protection for our agricultural community. It doesn't solve the problems. Suits still can be solved, can be filed, but now prior to a suit being filed, they have to attempt to go through mediation. And if they may go through mediation, but when they file that final paperwork to court that says we're bringing a complaint, they have to show that there was a mediation attempt being made when they file this particular thing. And if the mediation doesn't go the way they want it to go, they can, and then they have to do this together as far as the finances are concerned. Then they go as far as doing arbitration on this particular.
I'm sorry. So the case that we hear is the manure case. So farmer spreads manure, neighbor doesn't like it. They argue, I'm going to sue you. Burden of proof is on the neighbor. They I don't know how how you prove that it smells other than, what do you, how would you, how would that burden proof be for the smell? I mean, who's the authority in that case?
That is yet to be determined. Whoever has the best nose in the neighborhood, I would assume. I don't know. The nuisance, that would be under the nuisance complaint, which is have to do with smells, noise, anything along those lines. Whereas trespass complaint has to do with wastewater runoff.
Yeah.
And that creates flooding or so on and so forth. The example that was used in committee was we had a couple of attorneys in there, one for, one against, and they both presented a very good case in the court of Senate Judiciary. So one of them showed this large stream with an abundant amount of water. Just there's no way. I mean, these farmers put drainage tile in, thousands of dollars, thousands of feet, but the water coming down through there was no way that it came from, in my mind, drainage tile. So it just didn't happen. And so when the other attorney got to say their piece, they said, well, what they failed to tell you that this was during July during our flooding process. So this is attributed to the water that you're seeing. And I'm not here to render any judgment on either party. This is what they presented. This is what we watch, and so on and so forth. So, but it's this simply doesn't prevent lawsuits, like I said earlier, but it does allow for farming community to be more protected in what they do on a day under general farming practices.
So basically, if they're just to help with the question Senator Major's asking, because I know right where he's at with it. If using the same example, the neighbor's complaining about the manure smell, but the farmer is following all the standard practices of farming, doing what they're supposed to do, not being, quite frankly, an ass, just, not spreading right up to their lawn. I mean, trying to do what they can do and spread their fields and all of that. Chances are that this farmer is going to be okay.
I think we have to look at, yes, to answer your question, I think we have to look at what's considered reasonable and prudent. Okay, a farmer driving across your lawn spreading manure is not reasonable and prudent. That's not general practices. But a farm going through the routine practices that anybody would to maintain their farm, and whether it's through the application of pesticides or application of manure, whatever that may be, if it's a generally accepted practice, okay, they'll be protected or shielded from that. But having said that, if we go to page 3, okay, page 5. Line 13, starts on line 12. Plaintiff alleging that an agricultural activity is a nuisance or trespass shall have the burden of proof by preponderance of the evidence, as we discussed, that the agricultural activity is not conducted in accordance with generally accepted agricultural practices. And I'm trying to find the page that coincides with it. I'll get through it at some point in time here, but
Maybe
page 4. Line 11.
Okay.
Practices conducted in a manner consistent with proper and accepted customs and standards followed by similar operations of agricultural activities in the state. Now, this just gives them more protection. It doesn't avoid the possibility of a suit. But the problem with this is there's no standard as we know it today as what is considered generally accepted agricultural practice.
So the person, the neighbor,
Yep.
who's complaining about the smell, will stay with what Senator Major fleshed out. Would have to, at that point in time, it's up to them to prove that the farmer isn't farming in the manner consistent with proper and accepted customs and standards followed by similar operators of agriculture activities in the state. So that the farmer would have to be doing something egregious or not in practice of what a normal farmer would do.
That's all the bill does. It doesn't protect the farmer from anything that falls outside the realm of a naturally accepted practice within agriculture. Here's a news flash for you. Okay, cattle manure may stink. Okay, so if you find that offensive, you may not want to live in Franklin County, Vermont, anyways, because we have a little bit of cattle manure up here. So, but generally speaking, the farming industry is brings in a lot of money to the state of Vermont. And it provides, I'm sorry,
4.2 billion.
4.2 billion. So we have to protect their right within the state if they're following the generally accepted practices within the state of Vermont here. And that's all this bill does. It doesn't give them any loopholes, doesn't give them any out on anything. They still have to abide by the law. The mediation is set up in statute. So everything's already in place. We're simply shifting the burden of proof to individual clients. Because the example that we gave was that we were given was this farmer, I forget his name, him and his brothers. The neighbor moved in after the fact. Boston, they hear from me. And he was told that they didn't want any money, but they're gonna continue this suit until they basically break them because they had the money to do just that. And those are, and I'm not here to say that happened or didn't happen. That's what we were told in committee. And those are the things that we need to protect these individuals on.
Well, yep, go ahead.
Thank you, Mr. Chair. So my throat's a little sore, I'm sorry. Kudos to the Judiciary Committee for this. This Agriculture Committee last term advanced a bill very similar to this, but it didn't make it to the finish line. But I think this is a really, really good compromise in terms of neighbors and farmers. You know, I've often used the example of somebody moved next to an airport and then starts complaining their planes landing all the time. Really? You know, and it's the same thing to me. If the farm is already in business and doing farming and you move in next to it, you made that choice. And as long as, and again, to Senator Major's point, as long as you're observing the RAPs, the required agricultural practices, and the burden of proof is now on the neighbor to prove that that's not being done, the chances of being sued are going to diminish, I think. Well, I'm curious, and I'm not sure in our bill whether we use, as I understand it, in judiciary, there are 3 levels of evidentiary proof, if you will, and you use the least restrictive one, which is preponderance of evidence. Clear and convincing is the next one, and then beyond a reasonable doubt is what we normally do in criminal cases. I'm looking at my prosecutor friend here.
That's essentially correct.
Yeah. So I don't know whether you ever entertained any notion of going to the next level, which would be clear and convincing, or if you were satisfied that a preponderance of the evidence was enough, kind of.
Well, and Senator Plunkett can, we use preponderance of the evidence and beyond a reasonable doubt. I'm not quite sure within the legal system where clear and convincing comes as far as in between. As far as the legal.
Yeah.
No, we didn't.
Okay.
It's like I say, it's very basic, lowest level they can file.
Yeah.
They just have to prove whatever they allege. I mean, we had an instance where we had an event going on, a family event going on. Fuel was right behind the house there, and that day before, the farmer came out and spread like manure all over there. Okay, now had we approached the farmer, which would have been the ideal thing to say, listen, tomorrow we got an event going on. We know, can you hold off one day? It's just opening up an avenue for neighbors to be neighbors is what it's doing here. And this protection is offered for both sides, in my opinion.
Well, and I think what I like in this bill is that you go even further and you actually, on page 2, starting on line 10, you define activities, and then you say the General Assembly finds that the agricultural production is a major contributor to the state's economy. The agricultural lands constitute unique and irreplaceable resources of statewide importance. And it goes on to explain about how important it is to the state of Vermont. So, I mean, in that way, in its own way, it actually gives more protections as far as outlining how important agriculture is to the state of Vermont. So I'm glad that part's in the bill.
Well, as you well know, I didn't go over the findings because this is a House thing versus a Senate thing. I probably should have gone over at least that portion of the findings. Yeah. So we're going to take a vote on this today. I feel quite comfortable it's going to come out of judiciary today. What the vote's going to be, I'm not 4-1, 5-0. I'm not sure.
Okay, I was gonna, are we looking at 5-0 coming out of that?
We're hoping for a 5-0. Obviously, it's a very good bill.
What is
5-0, not you as a former, correct, police officer, but 5. So, you just got it.
Yeah.
Just got it.
Okay.
yeah.
I'm out here.
Yeah, we'll say that.
I do have one question on the discussion on the 5 years, essentially where farming shut down, can be sold to somebody else, could be doing anything else there, and then restart as a farm within 5 years. Was there any discussion on that term or how long? Why was that length determined, I guess?
Yeah, I don't know. It was just.
I might be able to add a little bit to that.
Okay, yeah, great.
Oh, you
Yeah.
can share.
So we have a situation and it's not actually not my district, but it's used to be, and it's, you know, I still do a lot there. I actually live there. I own properties there. We had a commission sales barn in town. It hasn't been a farm in my lifehood, 60 years. They had commission sales there, and the guy had auctions and sold junk, and then they would also once a week or twice a month, they would run livestock through there. It's a barn right in the center of town. Hasn't been a farm. Well, guy bought it and he leased it to a guy, and the guy has 200 pigs, he has goats, he has everything. It sits on a quarter acre of land. He's got 5 acres there, but a quarter acre of it's usable. And and he's bringing in product from a cheese manufacturer that's spoiled and done and just sitting there, and it stinks. I mean, it goes above and beyond the comparable actual farming practices of anything, but he's protected under the laws of farming. So it does, you know, go the other way, and everybody around there is like, and there's flies and it's everything. So
Okay,
if so what the town would have said at that point in time, listen, you haven't been a farm in 5 years' time.
okay,
And now you're starting farming practices. We're not gonna tell you that you can't do what you want to do, but now you're going to have to comply with town rules.
Mhm.
You're not blanket covered as far as on that. So I don't know if the 5 years, I don't know if the 5 years is correct. I don't know if I got to that, but it's just kind of the story about why I think that, you know, chairman of ag, I am going to side with farmers probably most every time. On that case right there, I'm gonna side with the community.
so that example was, this hadn't been a farm in a long time.
Yeah,
And so this will be like, okay, 5 years is the cutoff.
all right.
All right.
Yeah, so that's why I like that in there.
No, that makes perfect sense.
And normally with any decent meadow, if I stop farming, he comes along, I wanna rent that. You know, any decent farming land does not set still.
Yeah, I mean, I was picturing, you know, some situation that it really couldn't happen, but a farm stops being a farm, they sell it to a developer and condos are put up. And then within 5 years, those condos are taken down and it's a farm again. But that's not what this is.
Right.
This is more what you're talking. about.
Right,
That makes a lot sense.
more of making them accountable to the community, that they're gonna go back in and try to be a farm again.
So I guess I'm sorry. go ahead.
No, I said to that end, so the flip of what Senator Collmore said, if you have a neighbor and then someone comes in, buys a plot of land and then turns it into a farm, this does not apply.
No.
Okay.
They have to go through the town.
If it had never been a farm.
They have
Yeah.
They have to go through a town.
No, I like that.
And unless there are any more questions, I would close with, go ahead.
Well, I do. What do you think the changes are? That you said they're minimal, but you know, minimal turns into maximum sometimes. What do you think the changes are that you guys are gonna, what are you guys, still, discussing and trying to make the bill better as far as in the changes?
We aren't trying to do anything more with the bill that I'm aware of. We simply got our calendar put up again this morning. Michael Brady's coming in and we're gonna simply address whether or not there are any final changes and where we are, and then we're gonna vote on it. Okay. That we're aware of. But like I say, it's a good bill. It doesn't solve all the problems. It still gives both parties the right to do whatever they want to do, you know, under generally accepted farming practices. Someone still can sue. It's not going to stop the lawsuits, but shifted the burden. And there's the mediation process, the arbitration process.
And that's the other question I wanted to ask. Is it a determinant of where the mediation is? Is it a,
That's set up by, you know, statute. It's in the bill here.
okay.
Mediation first and then binding arbitration if that doesn't.
Right. But mediation is defined as far as an ag, as far as where that mediation will happen.
Yeah. Ain't something here.
It's nothing that. I think it's on last time. The party of to mediate may agree that on
On the Uniform Mediation Act set forth in 12 VSA.
Okay, so it is, okay, that answers that.
So it's in here.
And the
Yeah.
binding arbitration is that they can agree to arbitration, not that they have to do arbitration.
So like, this is such a big bill because of the situation that we're speaking of, that the neighbors,
Yeah,
they had the state out there, they had the EPA out there. They were like, these practices are fine, and they still weren't happy, and they still could, continue to bring up things on the farmer. And it's just draw out of them when the state is saying the practices are suitable. They're, it's.
And on the flip side of that is the same example that I brought up, where you got a community where it hadn't been farmed. And yet they're protected under those rules, then I like both sides of it. I really do.
Yeah, agree.
Actually, if I might, this was part of the problem they said was it was affecting their drinking water. If I might just pass this around, it's just, that's the water, the area they were complaining about. And so they took,
Show us a picture of it and then drinks it.
that's the farm that they were complaining. So the farm took a picture of the water and she washed her hands.
This was, the attorney was now then on this one,
Yes,
and they won in the end. Their call.
I
Yeah,
have no idea. I didn't get into.
I think that one was actually pretty egregious. I don't know the details.
They passed it, if they passed the results around, but I can't read them. I don't know what they're making. They had tested and it fell far below the
There's no
requirements.
E. coli in it.
Well, the natural water, yeah, it's not even it's not just water, it's a natural.
Maybe that's why if the event was successful, maybe it's why the other attorney came in so aggressive.
Maybe, I don't know the details. I spoke to her a little bit. I know her, I talked to her a little bit about it.
But she did provide a video of this stream / river going through along with the dump to the lake. You want to take a look at that?
They had tried mediation a number of times.
Wasn't going to work.
Just in that.
Yeah.
where was the farm? Just curious.
See?
Out in, Penn.
Okay,
Well,
What happened years ago is, what really started it was, there was a row of trees that people liked alongside the road and the farm decided. They got a few and people got excited. And they said, well, it's all the farmers. Put a row of trees out.
Mm.
That
I
really,
won't comment on what I've heard about both sides.
yeah.
And I'm not here to defend one party or the other. I'm saying this bill offers protection for both parties.
Yeah, my understanding, even with that, it wouldn't have changed that lawsuit.
Probably not. No, it's, they still can file suits. It doesn't protect them from suits being filed. It will establish what is considered general farm practices once it's under litigation. Obviously. Oops, I left that alone. My bad.
Very good bill. It protects both parties. But it does,
It works for
again,
both
it protects the farmer saying, you don't have to prove you're innocent, they need to prove you're guilty.
Okay.
Which is, I think, fair. Because then you can make any accusation.
Well, in criminal procedures, okay.
I mean, there was. I don't go get into the lawyers.
well, please.
I mean, there was a rebuttable presumption that was there, but essentially the defendant had to prove the rebuttable presumption before they got the rebuttable presumption, which usually is a very strong thing for a defendant to have a rebuttable presumption. But the three factors were completely unclear. So I'm not second guessing judiciary. I would have described it differently. No one would have understood.
But we don't get paid as well as attorneys.
Yeah,
I work for the state. Come on.
It's the benefits you reap.
It is true.
I work for the state also. I wouldn't use the benefits. So.
Well, I think that to help Senate Judiciary out, that we at least take a straw poll as far as what we think of this bill. So I'm just gonna ask, an aye from anyone that thinks it's a good bill. Aye. Nays. We have five ayes. So we want to thank you very much for coming in. And thank you for your hard work. And I'm gonna, I don't know how many years it's been that it was trying to get passed on something like this. been a long time. I keep on saying 10 years, but
Yeah.
I know it's been a while. And, I think, I'm appreciative of what you folks have done.
Well, the committee worked diligently on it, shall we say. I appreciate coming in. God, I love this.
Thank you, Senator Norris. We've got,
I think she's, I haven't heard confirmation, but I believe that Carolyn will stay.
okay, why don't we just take a 5-minute break and,
No,
then we can get started again.
We're just waiting.
We don't really have a whole bunch, but we got started, at, 10 minutes, 15 minutes.